Mhm.
Mr. Heinzen, you don't look like the same Mr. Heinzen.
Yeah, I can unmute you. There you go.
Is that good or bad?
I don't know. Well, your voice matches, but you look different.
You look more relaxed.
I feeling a little. I'm feeling a little relaxed right now. Yeah, I don't have my tie on. I'm
I
sorry.
know, I noticed. Hmm.
Maybe that's it. I don't know.
Maybe
I
that's it.
looked over like, oh, who's that? And then I look at the name and oh,
No, I'm fortunate enough to be visiting my daughter right now, who's doing a semester overseas. So
Oh,
oh,
wow.
and
just fine.
All right.
Yeah,
that's nice.
Well, yeah, I can't use my PC out of the 48 states. I can't, the state won't let me log in. So
is that right?
yeah, I'm state bound when we have work to do. But I'm glad you're able to, they can
it is
accommodate.
a it is a fortunate. That's the one thing that came out of COVID that wasn't horrible, I guess.
Mm-hmm. Mm-hmm.
COVID saved us the first year because we were leasing a car and we were way over mileage. And then COVID came. And then we came in under mileage.
Yes, I imagine so.
hmm It was dumb to do a lease to begin with, the amount I drive all over the state.
Oh, well, this, you don't have to worry about wearing your car out though.
Yep.
All right, so we got more people joining us. Thanks, everybody. We will get started as soon as I think we're waiting for one more party, possibly. Another minute or so to get connected. And just a reminder, we're live streaming on YouTube, and there'll be a recording of this on our YouTube channel. And just so there's no confusion, so that recording is an unofficial version of the record of the pre-hearing conference. We will have a transcript that'll be filed on our ERF system that'll represent the official version of today's events. Double check our. All right. Well, we are past time, so it's like if everyone I was expecting, except for the Promised Land Ranch and Preserve. But we will proceed without them at this point and see if they can join us later on. So let's get on the record. Welcome, everyone. This is Docket 137 CE 121, the application of American Transmission Company for a CPCN in what we're calling the Mill Road-Granville Transmission Line Project. My name is Michael Newmark, the Administrative Law Judge for the PSC. Welcome here, everyone on Zoom. We have the parties and commission staff in attendance, and let's do our our appearances now on the record. So I have the service list presented on the screen share for everyone's review, and I don't think I've sent this out to anyone yet before, but just an important note about the service list is these are the emails, in particular, the email addresses are what I'll use to communicate to you and what you should be using to communicate with each other in terms of service of documents. Obviously, that's pretty obvious for most people, but so when you're reviewing the list here today, can you just make sure we have everyone you've intended to include on the list, and if we have any errors on that list, let me know. If you're let's take it from there, actually. So let's start off with American Transmission Company. Who do we have representing ATC?
Brian Potts and John Sagoni's also on behalf of American Transmission Company, LLC, and ATC Management, Inc.
All right. Do I have everyone that you've requested on the list?
Yes, although I don't see John on there. Is he a part?
Yes, that might be true. All right, I'll make an adjustment now. All right. So let's continue on. So I'm going to just go down the list in alphabetical order. We may have a few repetitions here this time. So for CMDM Lilly LLC.
Good morning. This is Attorney Kevin Pollard appearing for CMDM Lilly LLC.
Okay, so we have Marcy Road Property LLC.
That's also me, Kevin Pollard.
Okay, and Marcy Road Property 2 LLC.
Also me, Kevin Pollard.
Right. Milwaukee Lawn Sprinkler Corp.
Appearing on behalf of Milwaukee Lawn Sprinkler Corp., Jeffrey Leota of DeWitt LLP.
Public Service Commission.
Sophia Rogers for the Public Service Commission. Evan Weitz will be co-counsel in this case, but isn't here at the moment.
All right, Sean and Rachel O'Brien.
Attorney Kevin Pollard appearing for Sean and Rachel O'Brien.
Okay, Promised Land Ranch and Preserve. Still not connected. Okay, so the Todds, who's representing them?
Yes, representing Paul and Jennifer Todd and Michael and Gail Todd, Jeffrey Leota of DeWitt LLP.
Okay. Yes, that's right. Okay, and the Weimer property?
Jennifer Weimer representing ourselves currently, possibly retaining an attorney soon.
All right, great. Thanks for letting me know that. Wisconsin Industrial Energy Group.
Yes, Your Honor. Steve Heinzen for the Wisconsin Industrial Energy Group.
All right. So I did have a question. I just want to discuss a little bit. So I did want to say, in terms of parties, there are no objections to the notices of intervention. I was prepared to grant the requests. I did want to mention with respect to the Promised Land Ranch, we had them file an additional explanation for their intervention out of time. I don't know if we provided an opportunity for any there is an opportunity to respond to that, but since there may be some confusion among parties, let me ask if there's any objections to the Promised Land Ranch's intervention.
No objection from the applicants.
No objections from the Todds or Milwaukee Lawn Sprinkler Corp.
Sure. No, none from Wisconsin Industrial Energy Group either.
And I'll just take silence as consent here. So I can name all of the interveners, parties in the case. So ones that you see on the screen here, including Promised Land Ranch. But let's discuss, we don't want to do this off the record, just in terms of organizing the case and how we want to group parties together.
Your Honor, sorry to interrupt, but I think there was another request for late intervention yesterday.
Yes, you're right. So we did have the CMDM appearing here today, so I can accept. Well,
Yeah,
let me ask any.
we also don't have an objection to that one. So I just wanted to make that clear.
Great. Thanks for reading my mind there. All right. So yeah, so I'll just note any objections to CMDM. No. Okay, hearing none. So we'll make them as well parties to the case. And just so you know, I will be issuing a pre-hearing conference memorandum that'll just document what we're doing here today. So it'll include an updated table with the new additions to interveners. So just in terms of grouping interveners up, we can do that off the record. So well, let me just say up for the record. So we're just my inquiry here is we have a number of landowner interveners that I'm assuming have similar interests in the case, and because some of them have retained the same attorneys, I'm also assuming there are no conflicts. But having said that, I was curious about whether there's a way to promote efficiency in the case by having parties group up into various configurations. Possibly the most logical one would be to have the groups that are the parties that are represented by a single attorney group up together for purposes of the hearing process. One caveat with that, I think there's one maybe detriment to doing that, which would be each party has the right to file a brief or initial brief and reply brief in this case. So effectively, by grouping up, I assume that what that does is limit your number of pages that each party will have to make their argument. We can make some adjustments to that. The other item may be in terms of discovery, the number of discovery interrogatories and requests for production. There's the limit in statutes. I think we can also make adjustments to that, recognizing that each individual intervener is technically a separate party. So I don't want to limit parties' rights by grouping people together for efficiency's sake. So in that spirit, we'll see some adjustments, but I'm just curious about whether that's a possibility. Don't necessarily need to force this to happen, but I think it's pretty logical and obvious that we do this. So let's hear first from Attorney Pollard, and I think it's the Marcy Road properties and the O'Brien property, the O'Briens that we'd be consolidating. Is that correct?
Yes, Judge. I think it would be appropriate to consolidate the Marcy Road Property LLC and Marcy Road Property 2 LLC with Sean and Rachel O'Brien. It's the same two parcels that are owned by these various parties. I am representing a different party who just filed their intervention. That's CMDM Lilly. That's a separate parcel, which I think if we could keep that one separate, that might make sense.
Okay. So any comments from other parties on that? On that first part anyway? No? Okay. And how about with Attorney Lyota's parties? Any opinion on whether we should do similar consolidation?
Yes, Your Honor. There's absolutely no problem. And Paul and Jennifer Todd, Mike and Gail Todd, and Milwaukee Lawn Sprinkler Corp., their interests are all aligned. They can be viewed as one party.
All right, great, thank you. So we'll indicate that in terms of party. What you'll see then in the pre-hearing conference memo will be a difference in that party identifier. I'll come up with something that just groups those together. And for those of you who haven't practiced before the commission before, or that I can recall, party identifiers, sort of a new idea, but it's you'll see it in your the format for filing. So you'll want to use that party identifier, and I can just show you quickly in the facilitating matters order. The party identifier is this what comes in between the name of the testimony, the round of testimony, the party identifier, and the witness. So you just want to stick that acronym in there for your page numbers and for citing other parties or your own previously filed filings. So that's where that comes into play. It's just good to know that ahead of time so we don't have to correct things after the fact. All right, so you'll see a change to that. In terms of briefing, and I suppose it just kind of came to mind that the discovery would have an implication for discovery as well. But so briefing, we have on the merits briefs, the initial brief is 30 pages per party, and then reply brief is 15 pages per party. So as not to impact negatively parties that are consolidating. I don't think we necessarily need to give 30 pages for each consolidated party, but something greater would be okay for me. Does anyone have a suggestion? How many pages you think, or maybe 30 is enough for a consolidated party?
Your Honor, from
Yeah, go ahead.
Todd's perspective, I would say that our issue in this case is very narrow and unique, and I think that's more than enough.
Okay. How about you, Attorney Pollard? Any?
I think 30 pages would be fine.
Okay, so we'll keep it the same. Thanks. And discovery, should we just play that by ear? I think if we count them all up, you'd have a lot more than 25, and I'm willing to allow that. Just want to let everyone know that each party would have that right to the number of interrogatories requests for production. It's not limited to the consolidated group. Okay. All right. So I think we have parties nailed down pretty well. Any comments, questions about that? No. Just curious, Jennifer Weimar, any idea when we'll know when you may have engaged an attorney?
I would hope this week sometime. I spoke with Kevin earlier, and we're considering our options with retaining Kevin Pollard.
Okay. Okay.
As we're right across the street from the O'Brien property.
I see. Okay, perfect. Well, that would make things easier for me, for sure. Can't deny that. All right, so let's move on then with issues. I don't know if you can see the text here on the screen share, a little small, but we all have a copy of this. So we have our standard issue, and that's what staff is proposing here today. It's not, I think the intent of this is to kind of encapsulate everything the commission needs to review and the statutes that it needs to follow in this process. So there may be some specific issues that are included in there. We don't have to list those out, but let me just get comments then from parties if there's any questions about the issues list. No? Okay. So included with the issues list, I wanted to mention sort of a kind of a unique issue when it comes to transmission line cases, and that's usually of interest to the to landowners along the line, which is the vegetation management that the applicant would be conducting if and when the project's approved and after construction. So I was just going to ask the applicant if they do intend to share that vegetation management plan in this case, that as it would apply to the project in the future.
That's a good question. I'm not sure I know the answer right now. I mean, certainly we have vegetation management plans. We know, or can describe how vegetation management will be done. I'm not sure the landowner, just looking at the maps, and I'm not sure I have all the different properties, but I'm guessing a lot of the landowners in this case aren't going to be that interested in vegetation management because the areas where we're going are pretty, at least I think all the properties are, commercial, but I could be wrong. I don't know if any of the parties have questions about vegetation management, they're certainly willing, or I'm certainly willing to talk to them about that and answer any questions they may have.
Okay.
But I guess I'm not envisioning this being like Cardinal Hickory Creek or one of the other ones, but you never know.
Okay. Okay. So just so you know, I think, it's certainly relevant to any transmission line case because it is potential environmental impact and landowner impact. So we can see how if parties want to pursue that. Commission staff may also want to pursue that. But yeah, given the specifics of this case, I can wait and see if the circumstances require the filing of the plan itself.
I just can't remember whether we've done that or not in this case already. Do you know whether the veg management plan has been filed? I mean, in conjunction with the application, I don't know how much detail was provided.
Yeah, I can't.
Commission staff, thanks to Judge Newmark, had just started looking into this and isn't prepared. I don't believe this was asked for in this docket yet, and commission staff is looking at how it may apply and asking the question in this and in other dockets as well. So we can work on that data request and follow up.
Okay, sounds good.
All right, great. All right, well, just want to let everyone know that they may be looking into that. So, all right, so let's move on to schedule. I think there's a alternative to the what staff had originally proposed, and I can share that on the screen share. Hopefully you'll have, maybe pretty small, hopefully you have your own version of that, but should be what we're working off of. So the adjustments here are in this column suggested revision. Does anyone have comments on that, or is this something that's already been, parties are aligned with?
I mean, this was emailed around and the applicants agreed to it. I'm not sure about the new parties who just joined. They might not have seen this.
Judge, if you want to scroll down, I listed out who had gotten confirmation. There it is.
Okay.
And you had pointed out that DM Lilly LLC was represented by the same.
Right, the same attorney. So potentially we have agreement. Let me hear from is it Attorney Pollard? Is CMDM?
Yes, we're fine with the change.
Okay. So I did want to mention, I know we did move the party hearing session, where the proposal is to move it from the May 29th to May 30th. So that's moving it from a Thursday to a Friday. I would do that with a little hesitation, just because I'm trying not to tax all of us with one-day hearings when we think that we could really benefit for the use of more time. So having it on a Thursday would allow Friday to be a spillover day in case we needed it. It's kind of hard to predict at this point, but I did hear from at least Attorney Lyotta that parties that attorney's representing are fairly limited. Is that the case across the board, or do we have some people who are going to go, arguing need and other more technical or maybe more broadly encompassing issues that may require some more time for a hearing? Any sense of that from how you sit here today?
It's hard to say at this point, Judge, as I've got a couple different parties that I'm representing, so.
I understand. Okay. Well, I know there was a desire to move from Thursday to Friday, but I do hesitate to do that so that we are kind of boxed into a Friday hearing. And I'm actually not going to be in town the first week of June. So I think we're going to set that back to May 29th, just to be on the safe side. Okay. And the other question then in terms of the hearing is for cases where we have they seem fairly manageable in terms of the number of parties and the fact that most of them at least are represented by attorneys. There's an opportunity to conduct these hearings Zoom only, or we can have you come to Madison and we do the hearing in person or on location in Madison, and also have a Zoom connection available if necessary to connect witnesses that need to connect that way. Any opinions on that?
I mean, I always prefer in person, but I'm in Madison, so I'll, do whatever needs to be done.
Okay. Anyone else?
Your Honor, yeah, from my perspective, it's fine either way as well.
Okay.
I'd say it's fine either way. I certainly don't have a problem coming to Madison if need be.
And I have no objection either way. I'm in DeWitt's Metro Milwaukee office, but going to Madison is not really not a burden for me.
Okay. Well, I think setting it on Thursday actually does create a complication for us doing it at the hearing in the hearing room, because we use that room for commission meetings and those are conducted in the same room. So let's set it for Zoom at this point. This will kind of cover our bases so we have the time and space to do what we need to do. So I apologize. That slipped my mind at the point that we won't have the room in the morning. Okay, so the rest of the suggested revised schedule is fine. So I can improve that with the caveat we'll keep the party session at May 29th. So you'll see that schedule in the pre-hearing conference memo. Otherwise, we can move on to any questions or comments about the facilitating order. So try to communicate that to people who are new, but it's basically when I issue the pre-hearing conference memo, all of these facilitating matters will be will apply to this docket, to this proceeding. It's a fairly standardized procedural document, something that and for non-attorneys, I just wanted to mention that. So it does impose a burden, especially with pro se parties. But the concept is commissioners are looking at these documents in multiple cases at once. To have a standardized view across the board really does facilitate their review of the record and is in your best interest to comply with. So the big consequence of filing something incorrectly, I'm not going to reject your filing, but we'll make you refile and correct it, which you'll see is enough of a burden to want to avoid in the first place. So what I would say is please review the facilitating matters document. We can discuss it. It's not applicable yet. So if someone does want to propose changes or has comments, needs clarity, we could do that now. But generally, this is what the standards that we use for filing documents and what the commission is expecting to see. So are there any questions, anything stand out or need clarification? No. Okay. I just wanted to point out especially for new practitioners before us, there are just a few pitfalls that I see quite frequently. So we have in terms of creating your documents, we do have people are putting documents in terms of exhibits, documentary evidence can be taken from the internet, or documents that include hyperlinks or citations, bibliographies to other documents. Because the commission, at least we're operating on the assumption that we're using an electronic file for the commissioner's review. in order to delineate what's in the record and what's not on the record, I include these disclaimers on each document that basically informs everyone, including the commissioners, that the citations that are being that are included in testimony or exhibits are not part of the record, just by virtue of them, the citation being in the document. So for testimony, we're looking at bottom of page 4, reviews that and provides the acceptable text for this disclaimer. So if you're citing something that the intent is that you're citing something for other parties to understand the source of your conclusion or your statement in testimony, but you're not offering that document in the record, that is acceptable so long as you include the disclaimer so that commissioners and other people aren't wondering what's in that document and go looking for it. And then once, so that's one item to look for. And then in terms of exhibits, there's a standard text for that as well. That just goes on the cover page. So that'll be page 9. Just saying that any citations here in this document are not offered for the record. And we used to make people try to scrub documents with take documents, hyperlinks out of documents, scrub them out of documents. It's okay, as long as you have a citation, just add that to the cover page. If you're going to be filing documentary evidence, please do not add any text to the original document. So people have tended to put page numbers on documents or their witness designation, the exhibit mark. Just leave that for the cover page and leave the documentary evidence as you have it in your possession. Well, those are things that usually stand out, and we have to have people refile. So I wanted to give you a heads up. The other thing in terms of this case in particular, just wanted to review. So the applicant usually does have some information that in transmission line cases it designates as critical energy infrastructure information, and that, because of its sensitivity, we have been treating that with special handling procedures. So I'm sure that there's a few documents already filed in this way, and you'll see that on IRF. But I guess what the main point of what I'm trying to say here is that if we can keep CEII to the extent we can possibly do it, keeping it out of offered evidence, that would be. Oh, we have someone join us. Hang on. Go off the record for a second. So I do see we had a phone call just join us, a phone number ending in 234. You'll need to press *6 to unmute your phone. I'm just wondering if this is possibly our Promised Land. Timothy Winter, is that you? You need to press *6 to unmute. It's a 919 number. I'm not sure if that's. Nope. Okay, they dropped down. All right. So where was I headed? So let's get back on the record. So in terms of critical energy infrastructure information, to the extent we can avoid including that in offered evidence, I would appreciate that, because it does impose some significant changes to our process in terms of how we retain and share that documentation. And those documents do need to be shared with the commission, the commissioners, and there's commissioners do like to have as much information as they can in the public domain in order to discuss the record. So there's the difference between CEII information and just regular standard confidential information, trade secrets, information that qualifies under our normal confidential handling process. So another way, so the extent we can leave CEI out of the offered evidence, that would be a good thing. To the extent we need to just refer to something differently, just giving it a sort of a cover name, so we're not repeating something we shouldn't be in public. That would facilitate discussion that we understand, but doesn't necessarily release information that we're not allowed to share with the public. So if there's questions about that, let's just handle that before we file documents and before we discuss them on the record. Just wanted to put that out there, a heads up. Also, in terms of sharing CEII, so parties should be able to access whatever the applicant files on IRF in the docket, as well as, of course, documents that are coming in on discovery and documents that are being filed or offered for the record. So there may, I think you'll probably deal with this with the applicant in terms of signing the right paperwork to have access to CEII if necessary. But also in terms of sharing that document, we use a secure server to share that information. And I don't know how parties share that between each other. I'm not sure if that's something you can use our system for or not. But
That's shared separately from our system.
shared separately. Okay, thanks. So you'll have to work out
If
those
anybody
details.
needs confidential information, they should just reach out to me. You'll see when you're looking at the testimony, there's not a lot of places that have been redacted. And just to basically summarize so people know what it is, there's both DNR information, so the location of specific sensitive species is confidential information that has to be protected from the public. And so there's some and very limited confidential information, just literally the name of the species and the location can't be next to each other. So that's one. And then on the planning/need analysis, we're not allowed. There's a couple things that we can't share. One of the main one is the contingency that would cause the lights to go out, which should be pretty obvious why we're not sharing that publicly. So almost, I can't remember a time in which we've had to get into those confidential details in a transmission line case. So CEII has almost never been a problem. Business confidential information, we have had to deal with that a few times. But anyway, if somebody does want that data, you can get it. There's just a lot of documents that need to be signed before we can share it.
Okay. Yeah, and if I recall correctly, we do have in 137 CE 209, the upcoming case, there's an exhibit that's been filed that I think the applicant's claiming contains CEII. So that's why I was bringing it up. But yeah, if this
It's
avoids
like
it,
the specific contingency. So it's like if you take out this power line, the lights will go off. So we have to black out the power line.
Right.
So,
Yep. Okay.
But anyway, that's just from a high level for everybody else. Everything else should be public as far as I'm aware in this docket.
All right, good. So yeah, and then in terms of, if you're sharing confidential, business confidential information, that the commission has accepted the request for confidential handling, you'll need to password protect that. So when your service is by email, but email is not secure. So if you want to share that information, you should be password protecting the documents. So you'll need to come up with a shared password. That's why I'm mentioning it now. So in terms of preparation, if you're going to be faced with that, I don't know if you will, but if you're going to be faced with that issue, we'll need to set up a shared password for that. All right, I think that's all I can think of at this point. If there's no questions about the facilitating order. All right, and I would mention that in terms of your contact for questions about that, it's the assigned attorney in the case is your first line of attack. So Attorney Rogers or Attorney Whites can handle your questions. If there's something that they're having trouble managing, they can contact me and I can get my opinion on it. But again, this is for filing and for procedural questions. So that's how you would proceed with that. Anything else? All right, well, I'll be issuing the pre-hearing conference memo in the near future. In the meantime, just proceed with the schedule as agreed to. And you shouldn't see any changes with the pre-hearing memo. It'll just be documenting what we did today. All right, great. Well, appreciate everyone's attendance, and we'll be seeing you in May.
All right, thank you.
Take care.
Good day.